select May 14th meeting to order. Roll call, please.
Ms. Callis,
Here.
Ms. Callahan,
Here.
Ms. Rodabout,
Here.
Ms. Marsh,
Here.
Ms. Roby,
Here.
Mr. Gonzalez,
Present.
and Mrs. Hines.
Here. Has everyone had a chance to review the minutes? Do I have a motion?
I make a motion, we accept the minutes. A second.
Okay, it has been moved by Mrs. Marsh, second by Mrs.
Rodabout.
Rodabar. What is your motion, please? All in favor?
Aye.
It has been moved and second and unanimously for the minutes. Is there a disclosure of ex parte?
Yes. I had a neighbor come up to me at a neighborhood meeting to ask me
Just
about
with the
a
case number,
house
Yes.
on the,
just the case number.
oh, the case
Okay.
number? All right.
Did she tell you?
Case number 18.
Okay.
I believe we still have a quorum, so on that case, it's advised to just recuse. I'll let your board attorney actually
Okay.
explain it.
So I can,
Yeah.
I can,
That you disclose the ex parte communication. That puts the respondent on notice, and they can ask you questions to see if somehow you should be disqualified as to vote on their matter.
Okay.
But you have to disclose what it is that you gave rise to that, the case number 18, and
Okay, so on case number 18, the neighbor disclosed that there was an accessory dwelling structure behind the property.
did someone speak to you about that?
Yes,
And they were, what, a neighbor?
they were just a neighbor at one of my neighborhood meetings.
Okay. And is that the extent of it?
That's all of it, yes.
Okay.
Okay, so we don't have to.
We'll deal with that when case 18 comes up, if the person's here.
Okay, can we have the swearing in of our officers, please?
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Okay. Our announcements, please.
Yes, Madam Chair. On page 2, lien review 1, CEB 09-22-153 is going to be via Zoom, and also lien review number 2 is also via Zoom. Page 3, case number 1, CEB 03-26-61, 437 Fulton Street is in compliance as of May 11th, 2026. Page 4, case number 6, CEB 04-26-78, 800 Madison Avenue is in compliance as of May 11th, 2026. Page 5, case number 10, CEB 04-26-67, 715 Clark Street is in compliance as of May 7th, 2026. And page 7, case number 7, CEB 04-2679, 131 Tarragona Way will be via Zoom.
Which one was
Page
that?
number,
Case number 7,
Okay.
what page?
page 7, case number 7. I'm
we
sorry.
don't have-
Let me look. I'm sorry.
Case number 7 is back on.
Case number
Page
7 is
4.
on page 4.
I'm sorry. Page 4, case number 7. My apologies.
What was the address?
131 Tarragona Way.
Oh, wait, okay.
What's up?
It's going to be via Zoom. And then page 8. Case 21, CEB 05-26-92, 1129 Madison Avenue is in compliance as of May 11, 2026. And those are my announcements. Before I do that, I'm asking everyone if we please silence your phones. If you need to talk, please step out into the lobby and do so. Thank you.
This is page 8.
Okay, here are our procedures. We will be calling cases by numbers and for the most part in order as they are listed on the agenda. If there are any attorneys or police present, we will hear their cases first. When your case is called, please come forward and be sworn in. State your name and address for the record. If you are not the owner of the property, please state your relationship to the owner. Our proceedings are recorded, so please speak into the microphone. The board hears from the code officer first, and then you will be given the opportunity to respond. Please direct all responses to the board. Witnesses may also testify following the same procedures. Are there any attorneys or policemen here? Okay. Okay, thank you, Madam Chair. Okay. Our first case is CEB 0924-153, Eclipse Assets Management Incorporation, 234 Reaver Street. Ms. Kirk, please.
Okay, good morning, Sarah Kirk, Inspector with the city. My credentials are on file.
Okay. May I,
Will you raise your right hand?
hand and be sworn in, please?
Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
And can you state your name and your affiliation to this case?
Elizabeth Knights. I'm the owner of Eclipse Asset Management, Inc.
Thank you.
Okay, we're here from,
She's a petitioner.
is she here?
Go ahead, Ms. Knight. You can state your case.
I don't have my case number. This is my first time here, so I don't know what I quite need to state. I have an agreement in place with the city. We have 2 properties that were out of compliance, but they got 234 Reaver Street and 613 Willie Drive, but they got out of compliance because when the hurricane happened, Hurricane Ian and the other hurricane after that, even though we had insurance, the insurance company.
Excuse me, Ms.
There-
If you would look at your agenda that I gave you, the agenda.
Oh, I can't because my system is not switching in between
okay. So
the
right
two
now-
things.
Right now, you're discussing 234 Riva. They're separate. So-
Okay. Well, when the Hurricane Ian happened and the other hurricane after that, both properties were completely flooded, as well as we had roof damages. We did have insurance, but when we did file the insurance claim, the insurance companies have been fighting to pay those claims. In fact, we're still in active court with them, fighting to pay the claims. So that's been our delay and struggle really in holding on to the properties and making sure we maintain the taxes and so forward, just to maintain the properties until we get the cases settled, that we can get back to being able to get the properties back up and running as they were. But we have since got them into compliance with the city, and we're asking for the fines back so that we can get the work done on the properties.
Okay,
We have sold, we had other properties in the area, and we have recently sold one of them in an attempt, since we're still in court waiting on the insurance companies to use those funds to be able to rehab the property and get them back livable.
okay, now can we hear from Ms. Kirk?
Yes, staff's recommending to reduce the fine to $1,500.
Say it again.
Staff is recommending to reduce the lien to $1,500.
Okay. Okay.
Can I ask you why you never contacted the city after the property was posted and you received the certified letters? There was never any correspondence?
I actually never got the letters. The city actually do have all the letters back themselves. I never got any of the letters. I wasn't even aware that any of that was happening. But when I first became aware of it and I went into the city, they confirmed that they have the return. They got all the mail was being returned to them.
In that case, we always post the property, and that's what we did, per usual. Yeah.
Was there tenants in the property?
Wait, it's a while back. Let me look through my notes here. The original complaint was back in May of 23, and the complaint was regarding a bathroom being remodeling going on, tub. So there was somebody in there working on the property, and then the backyard shed. That was the original. I think that there was one of the owners was staying in there. That's to my understanding. I don't know. Honestly, I just don't know if there was a tenant in there at any time. There could have been. I don't know.
Yeah.
But I did post the property and give proper notice.
So this case goes back to May of '23?
Yes, sir. That is when I received the complaint.
Okay, so it's been 3 years. 3 years?
Yep, 3 years.
23, she
She
said.
said 23.
That was when the complaint was assigned to me.
And the property's in compliance now?
Yes,
So the city's asking 1,500
correct.
to reduce to 1,500. Okay, is there?
I'll make a motion. I motion that the lien in case number CEB 0924153 be reduced to the amount of $1,500, subject to being paid within 30 days, or the fine will revert back to the original amount. Should you have a problem making payment during that time, you need to contact the Code Compliance Division immediately.
I second the motion.
Okay. The City of Daytona Beach Code Enforcement Board hereby finds the respondent. Yeah, I'm sorry. Excuse me, I'm ahead of myself. All in favor?
Aye.
Aye, okay. The City of Daytona Beach Code Enforcement Board hereby finds the respondent, Eccles Access Management Incorporation, case number CEB 0924153, for the property at 234 Reaver Street, to be in compliance and order the respondent to come into compliance. It is in compliance. Okay. Reduction, okay. Subject to be paid within 30 days, or the fine will revert back to the original amount. Should you have a problem making the payment during that time, you need to contact the Code Compliance Division immediately. Okay,
Okay, thank you.
thank you. Did you get that, Ms. Harris? Okay, okay. Case number CEB 1123138, Eclipse Asset Management Incorporated at 613 Willie Drive.
Madam Chair, it's the same person, the same situation. You
Okay,
can hear from the inspector. She's already told you her part.
okay.
Good morning, Inspector Garcia, credential on file with the city. Staff's met with the owners, and the staff recommends that we reduce the fine down to $1,500.
Okay. Okay, do I have a motion?
I'll make a motion that in case number CEB 1123138 be reduced to the amount of $1,500, subject to being paid within 30 days, or the fine will revert back to the original amount. Should you have a problem making the payment during that time, you need to contact the Code Compliance Division immediately.
Second.
Okay. It has been moved by Mrs. Marsh, second by Mr. Gonzalez. All in favor? Aye. Aye. I motion that the lien in case number CEB 1123138 be reduced to the amount of $1,500, subject to be paid within 30 days, or the fine will revert to the original amount. Should you have a problem making the payment during that time, you need to contact the Code Compliance Division immediately. Okay, thank you. Okay,
The phrase should be I order, not I motion.
Did you order? Ms. Diaz should say,
I ordered the 1,500, I said the number.
okay, well, but now you order it. The motion's passed, so you're
Right.
ordering, so you don't have to say, I motion.
Okay, thanks. Okay, thank you, Mr. Gonzalez.
I just clarified
Garcia.
that this is
Yeah.
an order of the board.
This is new, so, okay. Okay, we have lien review number 3, CEB 0620119.
Thank you, Ms. Knight. You're finished. Did you understand what they said? Sorry. Did you?
Yes, so I don't know if I have to, so I know I have to come down and pay you guys within 30 days. Do I stay for the rest of the meeting?
No,
or
you don't have
do
to.
I have to do? Oh, I can leave?
Yes, ma'am. You can leave.
Oh, well, thank you guys. I appreciate it.
You're welcome. Have a good day.
You too.
Okay.
Oh,
Case number CEB 0620119, Trezor Rivera Estate, Angela L. Rivera Estate, and Victoria Rivera at 224 San Juan Avenue.
Will you raise your hand, sir? Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
And can you state your name and affiliation to this case?
Mark Oslislow, I'm a registered agent of the trustee of the trust. It's in
Thank you,
Atlanta.
sir.
Okay. Would you like to say anything?
Yes, so the names that you called out that were the violators on the case lost the property in a tax deed sale, February 2025. It was a vacant lot at that time, and I believe it was demoed in 2022. And so when I purchased it via tax deed, there were $30,000, a $20,000 lien, $10,000 lien, totaling $30,000 from the city. The tax deed department does a title search and notices people prior to the sale. It was a poor title search. They named numerous governmental liens in addition to the city's that were erroneous, did not attach to this property. And it took 15 months to convince the county that those liens, in fact, didn't attach, and the cities were the only liens that needed to be paid. So I accrued interest that whole time on the liens and other things because of the poor title search. So the city did receive in excess of $32,000 of my purchase funds toward these $30,000 liens. And there is a balance, which is the balance of the interest of $5,300 $100, which I've met with the city about and have an agreed upon arrangement for a reduction.
Okay.
So with that said, staff has met with him, and we recommend that we reduce the fine down to $1,000.
Okay. The lien has been reduced to $1,000 by the city. Is there a motion?
I'll make the motion that the lien.
If I could just point out something beforehand, you are the final determinant of what the amounts are to be
Yeah.
reduced. The city has a sort of
Recommendation.
shake hand agreement, but it's not a binding agreement, just so it's
Do you
clear.
understand?
Yeah, I'm glad you pointed that out, because the previous two cases owed quite a bit of money, and we kind of,
Okay. Okay, you've heard, is there a motion?
I'll make the motion that the lien in case number CEB 06-20119 be reduced in the amount of $1,000, subject to be paid within 30 days, or the fine will revert back to the original amount. Should you have a problem making the payment during that time, you need to contact the Code Compliance Division immediately.
second.
Okay. It has been moved by Mrs. Rockenbach, second by Mr. Gonzalez. All in favor?
Aye.
Aye. In case number CEB 06-20119, George Revere, be reduced to the amount of $1,000, subject to being paid within 30 days, or the fine will revert back to the original amount. Should you have a problem making the payments during that time, you need to contact the Code Compliance Division immediately. Okay, thank you.
Thank you very much.
Okay. Okay. Continued cases. Case number CEB 032661, Boland Investment Groups, 437 Fulton Street, is in compliance as of 5/11/26. Case number 2, CEB 012601, Robert Washerbeck at 3020 North Peninsula Drive.
Good morning.
Okay.
Inspector Quinn with the City of Daytona Beach Code Compliance. My credentials are on file. The respondent was first notified on September 28th, 2025. Since the last hearing, an after-the-fact permit has been issued, and he's waiting for the scheduled inspection with the building department. I have been in contact with Mr. Warbeck, and he couldn't be here this morning due to a medical appointment, but staff is recommending amending to the next cutoff to allow the inspection from the building department to take place.
Okay.
So the fence is up?
Yes.
Is there a motion?
I'll make the motion. I motion that case number CEB 01-26-01 against Robert Warbeck II at 3020 Peninsula Drive to be continued to the next cutoff date, which is 6/3/26.
Okay.
Second.
Okay. It has been motioned by Mrs. Rovers, second by Mrs. Marsh. All in favor?
Aye.
Okay. In the case number CEB 012601, Robert Washerback, against respondent Mr. Warbeck for the property at, 3020 North Peninsula Drive, be continued to the next cutoff date, which is
That's 6-3.
6/3.
6/3. Okay.
Thank you.
Okay. Okay.
Mrs. Hines, in the future, you should say, I hereby order that.
Okay.
Here.
Okay.
What did we
Madam Chair,
say?
you need a vote.
Motion carried, so ordered,
I thought we did.
instead of rereading it.
Okay. All in favor?
Aye.
Okay. Okay. Case number CEB 022532, Llewellyn Osborne Adam Jr., 320 Garden Street.
Morning Board, Mark Jones, Supervisor, Code Compliance Division. My credentials are on file. This case was opened back on May 3rd, 2024. Since last hearing, I've had no contact from the property owner, but all the corrections have been made except the roof replacement, and they are maintaining the property. The property is still on the redevelopment and neighborhood services list. It looks like the roof replacement will be happening within the next 2 months. Staff recommends amending to the August cutoff for compliance.
Okay. Gosh.
I'll make a motion. I motion the previous order of noncompliance in case number CEB 02-25-32 be amended to allow the respondent Llewellyn Osborne Adams Jr. at 320 Garden Street to bring the property into compliance or be returned to a proceeding before the Code Enforcement Board on 6/3 for, August 5, 26,
So you just repeat.
for consideration for a fine up to $1,000 per day.
Second.
Okay. It has been moved by Mrs. Roby, second by Mr. Gonzalez. All in favor?
Aye.
Okay. I hereby order that case number CEB 022532, Llewellyn Osborne Adam, for the property at 330 Garden Street be continued until August, the cutoff is August 5th. To August 5th, okay. And we did vote on that, didn't we? Yes.
Next case.
Okay, I was looking to see was she already. Case number 4, CEB 042664, Burring W. Strauntz Estate at 422 Garth Boulevard. Mr. Stinson.
Good morning, John Stinson, Code Inspector with the city. My proper cases are on file. Since the last hearing, there's been no contact, no movement, nothing moving on that property. The city would like to recommend the imposition of a fine of $200 a day to be kept at $10,000.
Okay. Is there a motion?
I'll make one. I motion to find that case number CEB
This one is-
042664,
This is a fine
that the
case.
respondent, Bernard
And you said
Strauntz,
it's hereby
who was
ordered.
previously found in non-compliant, remains in non-compliant, and therefore order a fine in the amount of $200 per day to commence on May the 13th? 14th, May the 14th, and to continue each day thereafter until the fine has reached amount of $10,000,
Yes.
or the property be brought into compliance.
Second.
Okay, it's been moved by Mrs. Waterbrock and second by Mr. Gonzalez. All in favor?
Aye.
Aye, okay. It's this one. No. I hereby order that case number CEB 042664, at 422 Golf Boulevard, Mr. Vern Strunk's estate, who has previously been fined in non-compliance, remain in non-compliance, and therefore order a fine of $200 per day to commence on May 14th. Okay, and to continue each day thereafter until the fine has reached the maximum amount of $10,000. Figures supplied by code officers depending on the type of property or properties is brought into compliance. Okay, thank you. That was case number 4. Case number 5, CEB 032650, Amy L. Haynes at 148 South Goals Drive. Mr. Clegg. Clegg.
Yes, ma'am. Officer Clegg, my credentials are on file. This case was first notified on November 28th of 2025. Since the last hearing, I've had contact with the owner. The property is occupied. Progress is being made. They just got the paint approved by the HOA at Pelican Bay on 4/24/26. City's recommending to amend to the next cutoff.
Okay.
I have a question. What does that mean, protective treatment?
That's protective treatment is like the wood, the fence. It could be anything that the exterior surfaces.
Okay.
Did you say continue to the next?
Yes.
Yes.
I'll make a motion. I motion that the previous order of noncompliance in case number CEB 032650 be amended to allow the respondent, Amy Haynes, to bring the property into compliance or to be returned to a proceeding before the Code Enforcement Board on June the 3rd for consideration of a fine up to $1,000 a day.
Second.
Okay. It has been moved by Mrs. Rockenbach, second by Mr. Gonzalez. All in favor?
Aye.
Okay. I hereby order case number CEB 032650, Amy L. Haynes at 148 South Gold Drive to be continued until June 3rd.
This would be amended.
Okay.
Allow the response.
Yeah, which is June 3rd, for consideration of a fine up to $1,000
Per day.
per day, yeah. Okay. Case number 6CB042678, Charles Smith at 800 Madison Avenue is in compliance as of 5/11/26. Case number 7CEB042679, Totola Sultan Express Trust at 131 Tarragona Way. Ms. Kirk.
They're supposed to be on Zoom.
Yeah, I'm sorry, Zoom, yeah.
Okay.
Hello, Madam Chair. Case number 7, which is a Zoom case, is not in the Zoom meeting.
Okay. It's, what, oh, he's not on.
Not on.
Okay. Okay, Ms. Kurt.
Okay, since the last, first notification for this property was 2/3/26. Since the last hearing, I have had contact, however, there's been no
Now there's
progress.
someone coming to us.
I'm sorry.
What the heck is that?
Oh, just, okay, I'm sorry.
Okay, no problem. Okay, therefore, staff is recommending a fine of $100 a day to a max of $15,000.
I'll make the motion that I find in the case number CEB 042679 that the respondent, Tortola Sultan Express Trust, previously found a non-compliant, remains a non-compliant, and therefore order a fine in the amount of
$100 per
Up to
day.
$1,500. $100 a day to $15,000.
$100 per day to commence on today, May the 14th, and to continue each day thereafter until the fine has reached the maximum amount of $15,000,
Second.
or the property is brought into compliance.
Second.
Second.
Okay, Mrs. Rockenbach made the motion, Mr. Gonzalez second. All in favor? Okay.
If I may, just so it's clear, the record should reflect the respondent, I assume, was notified of this hearing,
Yeah.
and they asked to be present on Zoom, and they're not here. So
Okay. I hereby order that case number CEB 042679 Tortola Sultan Express Trust at 131 Tarragona Way, who was previously found in noncompliance, remain in noncompliance, and therefore ordered a fine in the amount of $100 per day to commence on May 14th and to continue each day thereafter until the fine has reached the maximum amount of $15,000. Okay, 15,000 supplied, depending on the type of property or the property is brought into compliance. Okay. Case number CEB 042668 Neil Service LLC at 854 Derbyshire Road. Mr. Butler, please.
Good morning.
Good morning.
Inspector Butler, credentials on file with the City of Daytona Beach. As it pertains to 854 Derbyshire, the respondent was first notified on November the 3rd, 2025. Since last court proceedings, I've had contact with the property owner. Matter of fact, this morning, he's in New York City, just getting out of the hospital, been in there about a month and a half. Assured me that his lawn maintenance guy will be over there this week to get that issue resolved. Staff requests him into the next cutoff.
Okay. Is there a motion?
I'll make the motion. I motion that previous order of noncompliance in case number CEB 04-26-68 to be amended to allow the respondent NEI Services LLC at 854 Derbyshire Road to bring the property in compliance or be returned to a proceeding before the Code Enforcement Board on 6/3/26 for consideration of a fine up to $1,000 per day.
Second.
It's been motioned by Mrs. Roby, second by Mrs. Marsh. All in favor?
Aye.
Okay. I hereby order the case number CEB 042668 Neil Service LLC at 854 Derbyshire Road be continued until June 3rd to come into compliance or return to the board. Okay. Didn't do all in favor, did I?
Aye.
Okay.
Madam Chair, before we move to the next case, I have a question for Mr. Butler about this case. I noticed in the pictures there was an open electrical box.
Mm-hmm.
Is that wiring dead or?
It's actually dead. Squatters were in that property a few months ago. They actually tore the box open and jumped it. So since that time, P&L has been out there and rectified that. And it's currently vacant, and it doesn't even look like that. All that stuff has been cleaned up except the landscaping. So that's all left.
Thank you.
Yes, sir.
Okay. Next. Case number 9, CEB 042669, Ashnish L. Patel and Dipikapin A. Patel at 1324 Loft Wedge Circle. Okay. Mr. Butler.
Mr. Patel needs to be sworn in.
Will you raise your right hand, sir?
Yeah.
Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. I'm sorry. Can you say who you are and your affiliation to this case?
Yeah, I'm Avnish Patel. I'm the property owner.
Okay. Okay, Mr. Butler.
Okay, as it pertains to 1324 Loft Wedge, the respondent was first notified on November the 28th, 2025. Since last court proceedings, I've had contact with the property owner, and I've been in constant communication with Miss Misty Phillips. Staff requests I'm into the next cutoff, but I'm going to let Mr. Avnish explain what Misty Phillips has informed him of.
Okay.
Well, I have filed an application for the variance application, and they have a board meeting on June 18th. So they haven't taken any decisions. They have a meeting coming up in next month.
Okay.
Yeah.
And your
June 18th.
recommendation was what?
To amend to the next cutoff, Misty explained to me that, like you said, the meeting will be next month, not
After.
after this hearing.
Do you want to give him 2 months then?
Let's do it. Let's give him
Yeah.
60 days and see where it leads us.
Because there's no sense in
Right,
doing it for
having
next
him
month. He ain't
Right.
gonna go before the board.
I
for
agree.
Variance, okay.
Yes.
I have a question.
Yeah.
You were here before. and
Yeah, I was here.
They had no other meetings prior to June?
No, they had a meeting scheduled for May, in the month of May, but they didn't do any meeting in the month of May. So they had in April, and the next one is coming up in June. So I think the meeting was canceled or something in the month of May. Yeah.
I'll make a motion. A motion of previous order of noncompliance in case number CEB 04-26-69. Sorry about this. Avnish Patel and Cabin Patel at 1324 Loft Wedge Circle. To bring the property into compliance would be returned to a proceeding before the Code Enforcement Board on 7/1 for consideration for a fine up to $1,000 per day.
Second.
Okay, it's been moved by Mrs. Roby, second by Mrs. Marsh. All in favor?
Aye.
Aye, okay. I hereby order in the case number CEB 042669 against Avnish Patel at 1324 Lock Wedge Circle to be continued until 7/1 until 7/1. Okay. Thank you.
Thank you.
Ms. Mateo, okay. Case number 10, CEB 042667, Minor Foreman at 715 Clark Street. Is in compliance as of 5/7/26. Case number 11, CEB 032643, Elaine M. Fixner Trust and Avon L. Fixner Living Trust at 114 North Gardner Court. Mr. Beanie.
Good morning, Madam Chair. Inspector Ron Beanie, my code credentials are on file with the city. The respondent was first notified on October 21st, 2025. Since the last hearing, I have had contact from the owner. There has been progress to the property. Staff is recommending to amend this case to the next cutoff.
Okay.
Those are recent photos?
There should be some old ones and recent ones. Yes. Those are recent.
What is the progress?
He had a lot more stuff on there. The yard was really bad. That stuff that you just saw in that photograph actually was not there the inspection before. So he's in the process. He brings stuff on, a day later takes it out. I just happened to catch it, I believe, when the stuff showed up. Because previous inspection, none of that debris was there.
So you think 30 days is enough, or?
I do, yeah, because that stuff goes away very quickly. The only thing he's having a hard time doing is that tree that fell during a hurricane. He's an older gentleman. He works with this one little chainsaw, and it seems to malfunction quite a bit. So he gets a little bit done, and there's branches out there, and a little bit. If we could do 2 months, I'm good with that. Because of the tree and how old he is and trying to.
Okay.
I'll make a motion. I motion that the previous order of noncompliance in case number CEB 032643 be amended to allow the respondent Eileen Fitchner and Alban Fitchner to bring the property into compliance or be returned to a proceeding before the Code Enforcement Board on August the 5th. July the 1st, for consideration of a fine up to $1,000 a day.
A second.
All in favor?
Aye.
Okay. It has been motioned by Mrs. Rockenbach and a second by Mrs. Roby. All in favor?
Aye.
Aye, okay.
Thank you.
I hereby order that case number CEB 032643 against Eileen Fitchner for the property at 114 North Garner be continued to July 1st of this month. Okay. Thank you. Okay.
Thank you.
Yeah, you're okay. Thank you. Case number 12, CEB 042675, Ann C. Carlson at 345 North Seneca. Miss Tanner.
Inspector Iscani, co-compliance, credentials are on file. A respondent was first notified January 7th, 2026. Since the April hearing, I had no contact with the owner, and there's been no progress. Last inspection was May 7th, 2026, and the result was non-compliance. Staff recommends a fine of $100 a day with a cap of $15,000.
Nothing's been done?
She moved the fridge. That's it.
Okay, I'll make a motion. I motion to find that in case number CEB 04-26-75, that the respondent, Ann C. Carlson, at 345 North Seneca, who was previously found in noncompliance, remains in noncompliance, and therefore orders a fine in the amount of $100 per day to commence on today, May 14th, 2026, and continue each day thereafter until the fine has reached a maximum amount of $15,000 or the property is brought into compliance.
Second.
Okay. It has been motioned by Mrs. Roberts, second by Mr. Gonzalez. All in favor?
Aye.
Aye. Okay. Madam Secretary, it's been motioned unanimous. Okay. I hereby order in the case number of, oh my God, CEB 042675, that respondent Ann C. Carson, who has previously been found in noncompliance, remain in noncompliance, and to commence on May 14th, and a fine of the amount of $100 per day to commence on May 14th and to continue each day thereafter until the fine has reached the maximum of $15,000, supplied by code enforcement depending on the type of property or property is brought into compliance. Okay, thank you. Case number 13, CEB 012617, C&N Properties LLC at 527 Mark Avenue. Mrs. Hatana.
Respondent was first notified September 12th, 2025. Since the April hearing, I've had contact with the attorney, and they've submitted paperwork to the permit licensing department to get the permit approved. Last inspection was May 7th, 2026, and the result was non-compliance. Staff recommends we amend to the next cutoff.
Okay.
But the last meeting, they failed the inspection, so
Right.
they're trying to.
They got an engineer to write them a report to say that the roof was okay. So now the permit licensing department has to review that, and that's what we're waiting for them to review it.
Okay, what is your opinion is the roof needs to be replaced?
I don't know. I just saw it damaged, and the permit was for that, and then the permit department denied it. Now she got an engineer to say that it was okay. So now the building department has to look at it to
So
say
the damage hasn't been fixed though?
from what I can see, it has.
Okay.
But if the permit department hasn't approved it yet, then it's not okay yet.
Okay, so you wanted to cut off for next month?
Yes, because
Yeah,
we're
but
waiting
the
for
main-
the building department to sign off on it.
You think
But-
30 days is enough for the building department? I mean, I
I'm
know
hope-
they're changing hands and
I'm hoping so. I mean, they had submitted this May 6th.
May
So
6th.
That's when the Mark Avenue submitted it.
Okay.
Could I, in this case, there was work without a permit, right? Am I looking at the right one?
Yes, for the roof.
Yeah,
Yes.
okay.
Okay, I'll make the motion. My motion of previous order of noncompliance in case number CEB 01-26-17, C&N Properties LLC at 527 Mark Avenue, be amended to allow, to bring the property into compliance or be returned to proceedings before the code enforcement board. Wait a minute, I'm sorry.
Yeah, that's the fine or whatever, I think.
Yeah, I'm sorry, I'll start over. A motion to find that in case number CEB 01-26-17, C&N Property LLC at 527 Mark Avenue, who was previously found in noncompliance, remains in noncompliance, and therefore orders a fine in the amount of, cut off. Amended order. I motion the previous order of noncompliance in the case number CEB 01-26-17, C&M Property LLC, 527 Mark Avenue, to be amended to allow the respondent to come into compliance or be returned to a proceeding before the Code Enforcement Board on 6/3/26 for consideration of a fine up to $1,000 per day.
Okay.
Second.
Sorry.
It's been motioned by Mrs. Roberts, second by Mrs. Marsh. All in favor? I hereby order the order of noncompliance in case number CEB 01-2617 be amended to allow the respondent, C&N Properties, to bring the property into compliance or to be returned to the proceedings before the Code Board on June 3rd for consideration of a fine of up to $1,000 per day. Thank you. Okay. You all have to excuse me, okay. Case number 14, CEB 03-2644, Chester Smith III at 548 Sandra Avenue. Ms. Atana.
Respondent was first notified September 11th, 2025. Since the April hearing, I've had no contact with the owner, and there's been no progress. Last inspection was May 7th, 2026, and the result was non-compliance. Staff recommends a fine of $100 a day with a cap of $10,000.
Okay.
I'll make a motion. A motion to find that in case number CEB 03-26-44, that the respondent Chester Smith III at 548 Sandra Avenue, who was previously found in noncompliance, remains in noncompliance and therefore order a fine in the amount of $100 per day to commence on 5/14/26 and continue each day thereafter until the fine has reached the maximum amount of $10,000 or the property is brought into compliance.
Second.
Okay. It's been moved by Mrs. Rovich, second by Mr. Gonzalez. I hereby order that in the... Oh, all in favor? Aye. Thank you. Unanimous. I hereby order in the case number 13, is it 13? 14. CEB 032644. The respondent Chester Smith at 548 Sandra Avenue, previously found in non-compliance, remains in non-compliance, and therefore ordered a fine of the amount of
$100 a day. Yeah.
$100 per day to commence on May 14th and to continue each day thereafter until the fine has reached the maximum amount of $15,000. $10,000. Figures supplied by the code officers depending on the type of property or properties is brought into compliance. Thank you. Okay, case number 15, CEB 0625103, William Warren Thompson Jr. at 307 Garden Street. Would you be sworn in?
Will you raise your right hand, sir? Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Can you state your name and affiliation to this case?
William Thompson, owner of the property.
Thank you, sir.
Okay, Ms. Santana.
Respondent was first notified August 23rd, 2024. Since the February hearing, I have had contact with the owner, and they're waiting for construction from Transform 386. They've got their plans approved, and they have site plans. Last inspection was May 7th, 2026, and the result was non-compliance. Staff recommends we amend to the August cutoff.
Okay.
He's maintaining the lawn. He's doing everything he can do. He's just waiting to break ground.
Okay.
Yes.
They're very slow.
Transform.
So
They
what
move at their pace.
Yes,
So,
they do.
but I'm glad I'm
At least you're
glad I'm
not a
being
couple
taken
years
care
out. At least you're not a couple years out.
of. Yeah.
Is there a motion?
I'll make a motion. I motion that the previous order of noncompliance in case number CEB 0625103 be amended to allow the respondent, William Warren Thompson, to bring the property into compliance or be returned to a proceeding for the Code Enforcement Board on August the 5th for consideration of a fine up to $1,000 a day.
Second.
It is moved by Mrs. Rockenbach, second by Mr. Gonzalez. All in favor? Say aye. It's unanimous, Madam Secretary.
I'd just like to make a comment. I believe that August 5th is the cutoff date because this board meets the second Thursday, and it certainly can't be August 5th. Just trying to make sure it's so that Mr. Thompson understands that if he had to come back, he'd come back on
August 13th?
August 13th is
right.
the
August
hearing,
13th. Okay.
Yeah.
But if you not complete by August 5th, you'll be brought back on August
August 13th.
15th.
Right, yes.
Just so it's clear.
Right, yes.
Okay, so you said 15th or 13th?
13th?
13th, yeah.
Okay.
I hereby order that case number CEB 0625103 against William Warren Thompson Jr. for the property at 307 Garden Street to be continued until
August cutoff?
August 13th
But his property's brought into compliance
By
by August
8th.
5th. Otherwise, he has to come back to the next code.
August 13th.
Okay, but we're leaving him with August
13th.
13th.
August 5th is the compliance date.
Yeah,
That's when
I
the
know.
inspector makes the determination that the matter is now either coming back before you or not.
Okay. Okay, thank you, Mr.
Okay,
Thompson.
thank you.
Okay. Ms. Secretary. Case number 16 CEB 032645 La Casa Cater Villa LLC at 524 Sandra Avenue. Ms. Satana.
Respondent was first.
You have to swear in.
Oh, yeah, sorry. This is good.
Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
And can you tell me your name and your affiliation to the case?
My name is Nathalie Kowalczyk, and I'm the operation of the LLC.
Can you repeat your name again for me?
Nathalie Kowalczyk.
Can you spell your last name?
Kowalczuk.
Thank you.
Ms. Santana.
Respondent was first notified September 29th, 2025. Since the March hearing, I have had contact with the owner, and they have recently started an eviction process back in March. Last inspection was May 6, 2026, and the result was non-compliance. Staff recommends we amend to the July cutoff.
Okay. July cutoff. Okay. Is there a motion?
I'll make a motion.
Did she have something she wanted to say?
No, I'm in the picture now. Yesterday they gave me core day on May 26th, so then I can do before that day.
What's the date again?
May 26th.
Okay. I make a motion, the previous order of noncompliance in case number CEB 032645 be amended to allow the respondent, La Casada Villas LLC, to bring the property into compliance or be returned to the proceeding for the Code Enforcement Board on July 1st, 2026, for consideration of a fine up to $1,000 per day.
Second.
Okay. It has been moved by Mrs. Marsh, second by Mrs. Rockenbach.
Roby.
Roby, sorry. All in favor?
Aye.
Aye. It's, Ms. Secretary, we're missing one vote. Okay. I hereby order that case number CEB 032645 against the respondent La Casadega Villa LLC at the property at 524 Sandra Avenue be continued until
7-1.
7/1. Okay, thank you.
Thank you so much. Have a great day.
We're now hearing our new cases, which is either your compliance or non-compliance. There will be no fines given or anything today. You're either in compliance or you're not in compliance, okay? New cases, case number 17, CEB 052681, Claudia Lopez Velsco at 1128 Hampton Road. Would you be sworn in, please?
Will you both be, do you swear or affirm that the testimony about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
And can you both state your name and your affiliation to the case?
I'm Jacqueline Martinez. I'm the daughter of the homeowner, and she doesn't speak English.
Oh.
Claudia Velasco Lopez.
She can pull down the mic a little bit.
Claudia Velasco Lopez.
What's your name again, first name? What's her name?
Claudia.
Oh, Claudia, okay. And you're Jacqueline.
Jacqueline.
Thank you.
Mrs. Titanic.
This case was opened August 6, 2025, a complaint generic case for outside storage, beer services, work without a permit for the Section 3 structure, trash and debris, and damaged roof. First notice received August 12, 2025. Compliance is due September 12, 2025. Last inspection was May 7th, 2026, and the result was non-compliance. There has been contact with the property owner. Staff recommends a finding of non-compliance with compliance due by next cutoff.
Okay. Mrs. Velsica, would you like to say anything?
My mom, like a couple weeks ago, she cleared out all of the debris in the patio. The roof was fixed. She has picture proof that the roof was fixed. We did all the painting. We're just waiting on the structure that was outside in the backyard to be like, I think it was a survey. They called to come check it out and to like see the distance from the house, and we're still working on that part, but everything else is already finished.
Okay. So your recommendation was the next?
Next cutoff.
Okay.
They're waiting for their permit.
Oh, okay. Okay. Is there a motion?
I motion the respondent, Claudia Lopez Velasco, for the property at 1128 Hampton Road, be found in non-compliance and order the respondent to come in compliance by the next cutoff date of 6/3/26, or be returned for a hearing before the Code Enforcement Board on 6/11/26 for the consideration of a fine up to $1,000 per day.
Second.
Okay. It has been moved by Ms. Callis, second by Mrs. Roby. All in favor? Aye. It's unanimous vote. No, I apologize. One missing. Just not now. Okay. Okay. So this is continued, right? This is continued, yeah.
This one?
Yeah.
Yeah, no, it was found in non-compliance, but they have until
Okay.
June 3rd.
June 3rd, oh, okay. I hereby order of non-compliance in the case number CEB 052681 be amended to allow the respondent, Claudia Lopez, to bring the properties into compliance or be returned to the proceedings before the code board on.
This is the first one. That's the motion. You should have an order that says.
Yeah, this
that
is
I
the only
ordered
one
it.
I have. Okay.
This is
Do
the first
this
time
one.
I've ever
Okay, we're
heard
doing
false.
this. Okay, I hereby order the respondent named Claudia Veses in case number CEB 052687 for the property at 1128 Hampton Road be found in non-compliance and order the respondent to come into compliance by June 3rd, a next cutoff date, or be returned to a hearing before the Code Enforcement Board on
June 11th.
June 11th for consideration of a fine of up to $1,000 per day. Okay. Thank you.
Thank you.
Okay.
Thank you.
Okay. Case number 18 CEB 052693, Titus J. McCarter at 815 North Grandview Avenue. Mr. Stinson. Okay. Sir, would you raise your hands to be sworn in?
Will you raise your right hand? Are you both testifying?
I'm the attorney.
Okay. Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? I do. And can you state your name and your affiliation to the case?
Yes. First appearance here this
Right. Arthur Huggins, attorney on behalf of respondent.
I'm sorry, you said Abigail
McCarter.
McCarter. And your name again, sir?
Arthur Huggins.
He didn't swear. Was he sworn in?
Well, he's an attorney.
Oh, okay, okay.
Okay. What's his name?
I asked, so just came.
Arthur Huggins, I think.
Asked if any attorneys here. Okay.
I think they came in after.
Is your name Arthur Huggins?
Yes, ma'am.
Thank you so much.
Okay. Mr. Simpson.
Good morning, John Stinson, Code Inspector with the City. McCarver cases are on file. This is a complaint-driven case for working on property without the required permits. My last visit to the property was on 10 May 2026. Myself, an additional code inspector and building inspector made the appointment to be there to perform site inspection. We were met there by a contractor. Unfortunately, the contractor that we met there was only there to show us the portion of the property that he worked on. That particular portion of the property was properly done, permitted, and the permit had been finalized, and the building inspector was there to confirm that, and he did. However, the building inspector also pointed out that there were quite a few issues that still needed to be inspected and or corrected. The actual purpose of us going out there to the property was to inspect the entire property to view these renovations that were done without permits. However, there was only one small section of the property that was made available for us to inspect with that contractor. So we inspected that one portion. That one portion was fine, but that really wasn't the portion that we were concerned with. All the other locations on the property were inaccessible. Like I said, this was a complaint-driven case, multiple complaints actually, from the tenants and from their neighbors. Therefore, we're asking for an order of non-compliance and have them come to compliance by the next cutoff.
Hi, good morning, board. Again, Arthur Huggins on behalf of respondent. At the outset of this case, I think it's important to take a look at the allegations by the city. At the outset, the violation that was alleged was work done without a permit. This case stems from 2024. In 2024, when it was alleged that the work was done without the permit, respondent applied for a permit. Within 7 days, the permit was applied for on 4/15 of 2024, and it was approved on 4/22 of 2024. The work that was being done at the time was under permit as requested. At that time, respondent should have been in compliance because the remedy was to apply for a permit. That's what was done. 2 years later, they are now saying that they need to inspect the whole premises. If you look at the original violation, they never specified what work was done was being unpermitted. So the homeowner knows what work they were having completed at the time, and that's what they had permitted. In regards to them returning to the property 2 years later and asking to see the whole premises, again, I believe that it's speculative in nature in regards to what they're saying was unpermitted work because there's no pictures of any pre-existing condition on the property. There's no pictures of any after the work permit. In this case, the permit has now been finalized. It was passed by the city officials. She's in compliance. I don't know where the allegations are that there's some other work that has been done. There's no pictures of this work. There's no substantial evidence by the city that there's other work that was being done. This permit, again, has been finalized. She came into compliance way back in 2024 when she did what the city instructed, which was to apply for a permit.
My question, when it was brought up in 2024 with work without a permit, did we know what they were doing? Because on the property appraiser site, you can see where people apply for permits. So you can tell technically the kitchen's been redone. I mean, we know that the houses on this area are 50s and 60s.
Right, precisely.
So we know work's been done without a permit if there was no permits pulled.
And the permit was pulled again 7 days later for the work that was being done.
What was that work?
The work was the lanai that was in the back of the rear of the building was turned into a interior structure, and that's what she applied for. That's permit has been finalized. She had the engineer come out and actually do an affidavit as to the work that was done, that it was done in a workmanlike manner and according to the building code. There's a full affidavit. There's pictures under the permit showing the work that was completed. There's a drawing. I don't know what else the city is asking for at this point. Other than the fact that they want to see her whole property, which again, there's no allegations that there was any other work being done.
I do believe we have complaints.
Okay. Mr. Stenson?
That's correct. As I stated in the beginning of this case, this is a complaint-driven case. Not just one complaint. These are multiple complaints. One specifically from former tenant. Then you have at least 2 neighbors who have visually seen work being done on the property, not just the permitted part. As I stated in the beginning, there was a portion of the property that did have a permit. The contractor met us on the property and we inspected that one portion of the property. That is not the entire complaint.
So what work still needs, that does not have a permit?
This property, that you can tell by the pictures, it's listed as a single-family home on the Volusia County Property Appraiser. You're looking at this property right now, we're looking at least 3 units.
At least what?
3 different, separate, individual living spaces, units. Like I said, the complaint came from a former tenant, so clearly it's being rented as well. Easiest way to conclude this is to allow full inspection of the property, which is what we agreed upon prior to going out there this last time. However, all we got was the contractor who actually did the work properly. It was permitted, it was inspected, and it was finalized. The rest of the property has not.
Again,
So,
there's no proof of anything that he's alleging here.
Okay.
The one complaint that they have is an anonymous complaint. I don't see any complaints other than the initial complaint that happened in 2024. There was a permit applied for within 7 days after the complaint. If there's any new allegations, I think the city needs to bring a whole new case. Maybe if he's trying to claim some other action took place with regards to units, but she does have a renter's license as well in place. So we're here today for compliance with the 2024 violation, which says there was unpermitted work that needed to be permitted, and she has complied with that.
I got a question for the attorneys. Wasn't there something passed about that? There's no more anonymous complaints, that, you know, you have the right to know who filed the complaint?
Yes, they're not anonymous, right?
That's correct.
They're not anonymous complaints.
He
Would like
just
a
said
copy, they're on IMS.
He said anonymous. That's what I'm asking.
Yes, I didn't see any claimant. The claimant has to identify themselves as well as, and I don't see any
The
proof of
respondent
that.
also has to ask that for information. No discovery was requested. But if he would like it, we can provide that to him.
Okay.
Well, as
So-
we stand here today, we don't have anything other than Mr. Stenson's statement that there is something that happened.
Yeah, it's just
but
allegations.
I don't know what it is.
So we asked the board to issue a subpoena under Florida statutes 162.04 to force the respondent to allow us to inspect the property. That is your right under 162.08 subsection 3.
They've already inspected the property. They inspected the work that was done. There was a permit that was pulled, and the permit has been finalized. The work that was done in a workmanlike manner. Again, if the city is asking to inspect the whole property, I think they need to, again, do a whole new case in regards to what they're alleging, because they have not alleged anything other than speculation that there's some other units out there.
Is there a reason why the McCutters won't let the city in to see?
Well, they're not required to let the city
I
in.
understand they're not required.
They're not required.
But
So
if this can make the whole case go away,
well, it possibly can, but in regards to this case that we're talking about today, you're here to decide whether she's in compliance or not, and she's in compliance.
well, it depends on how you look at it, whether she's in compliance, because if it was work without a permit and it was complaint driven by a tenant, then there is something that the tenant has said.
Well, where is it? We need that evidence before the board. There's no evidence.
We're asking for a subpoena to obtain that evidence.
No. Evidence of the complaint, specifically what work was done that was unpermitted, because the work that was done that was unpermitted has now been permitted and it's been finalized. The permit is closed out, the work has been done. So I don't understand where, at this point, the city's overstepping their boundaries.
Okay, I'm looking at maybe if the board is okay to continue this, and therefore all the proof or allegations can be brought forth, and then you can make an accurate decision.
So I just wanted to remind the board, at this initial hearing, it's the respondent's responsibility to prove compliance. It's not our responsibility to prove a violation. We only need to prove the violation at the second hearing when we're imposing a fine. The case law for this, I can pull it up.
But he's posing the question that they came into compliance with the first violation.
We have complaints that say otherwise.
Okay.
Which is enough at this stage to prove our burden.
Where are the complaints? Can we have those produced on the record?
Once you officially request them, we can provide them.
No, at this time, you're presenting your case to the board. You're telling the board something, but you don't have your proof. So where's your proof?
Well, that's just like you're presenting a case of, but we don't have the proof from you that
Yes,
this
Judge.
was.
Ms. Himes, actually, you do have proof. It's part of the city's record that this permit was applied for on
Okay, you have it
422.
there.
Could you provide the permit, please?
That's the notice of commencement and the permit.
May I approach?
Yes, you can give it to her. Okay.
Do you have a copy of this?
I'm sorry.
Do you have a copy of this?
I'm gonna bring it to you, because if he had proof that it was. Okay. Commencement. This is when it started. Where's the compliance?
This is a notice of commencement.
Yes.
These materials, if I can ask a question. these materials pertain to the permitted work, which you said had been properly applied for.
Yes.
And had been finalized and was complete.
Yes.
And I guess in terms of this board, which is making a determination, at this point, all that the board has been presented with is that someone has alleged that some work was done sometime, somewhere. I still think, and correct me if I'm wrong, Ms. Diaz, I believe the burden of proof still lies with the city to prove something, to show something.
Let me pull this.
But, Ms.
And I'm having trouble with this right now, that I see this as more a fishing trip than.
Exactly.
Yeah.
I guess in that case, I could prepare a legal memorandum explaining that if we can get a continuance for the
Again,
next hearing.
we're opposed to any continuance. We've proved our case that we're in compliance. Again, if the city's alleging some other,
Okay, then if
I
you
don't
can
know.
have 10 minutes to print out the complaints and enter them into evidence.
Okay.
But
'Cause I don't
there's-
see
Standard,
a,
not standard
I don't
practice,
see a
but-
final in here.
Well,
That's what I was
I think that
looking
Mr. Stenson had, with respect to this, Mr. Stenson, this booklet,
for. No, that's his.
that's
What
his.
I was
For this
looking
permit,
for
it was
was
final.
a
yes, it's
final,
been
and I
it's been
don't see
finalized
it.
out.
Okay, but Mr. Stenson has testified that it was final.
Correct.
And it may not be there, but your
Yeah, I
witness
didn't
is
see it
saying
there.
that it's final. So.
Yes, the city is not objecting to the fact that it's final. It's public record that this permit was applied for within the 7 days after the violation was
Okay,
alleged.
I have another question. If we go with yours, that this permit was final and done, can we just move past this? And Mr. Stenson, can you write another code enforcement violation on the complaints that you have received?
That's what he's saying. He's saying.
I know, that's why I'm
that
asking.
if we could start with a new complaint, if we have a complaint.
If we have
Not
a
based
new
on that,
complaint,
yeah.
which I don't think there is. any.
I have a
On
question.
this one.
The people who made a complaint,
Yes.
that's under a certain number, you
Yeah.
know, the
He's not
violation,
showing me
the,
where the first
so,
one was
you know,
found.
the case number.
he's talking
So
about.
is it the same case number that they made the violation, the complaint
I think
on?
you're right. We need to.
The first complaint, yes. The other
Okay.
two are not.
And see,
The other two are new cases?
No,
No.
they haven't been.
No. They're not new cases, but they're the same complaint.
So that's why I'm asking if we go ahead and find in the respondent's favor and say she's in compliance for this violation
Only that.
from March 9th of 2024,
I can,
could you possibly come back with another violation and then for another case number, same name, same address?
we can't do that.
No, I
No,
can't.
I'm not saying we do it.
Oh,
I'm saying Mr. Stenson's gonna log another
Complaint case.
Yeah.
case.
no,
The complaints that we received are attached to this violation.
Oh,
There we go.
It would be a due process
Okay.
concern to, like a double jeopardy, if you want to think about it. It's not a criminal case.
Right.
It would be a different legal, yeah, but it's easier.
So
to put it
again-
in
But
a
this
cash.
violation seems to be settled though by the permit.
yeah, where?
I'm sorry,
Where is
Right.
it completed?
Right.
It is completed, ma'am.
Well, I didn't see it in there, that's what I was looking
I mean,
for.
Well,
work
if you-
without
if
a
you wanna look
permit
at-
is pretty vague.
Well,
If,
exactly.
right, exactly. It's all speculation. And again,
Right.
she actually complied. And I can, if you want to look at my phone, I can show you where it's finalized with the
Okay, I
city.
think he's looking that up now with the state, because that's what I need to see.
Yes.
And
And
you're
this is also the
saying,
architect's report signing off on that everything was completed.
right. You're,
But that's not our city inspector.
Correct.
con-
The city
Yeah.
inspector actually requested this, and this was provided to them.
Does that pertain to certain parts of the home or,
Yes, this pertains to the home under the permit, the work that was done.
right,
That-
what was it?
It was a addition to her
The
lanai.
lanai?
She made an addition.
So
She-
that's the only thing that you have the permit and the report for?
Yes, there's two areas that was there.
Okay.
and
So
that-
what What pieces of the building are in that area that the lanai was? What part of the house is?
It was an addition off the back of our property, and that's when we received the not in compliance. So then we applied for the permit immediately.
Okay, but was that for a the permit, was it for a living room? Was it for the kitchen? Was
It
it?
was for the addition to the back of our original apartment, because you're allowed to have a rental apartment where we're at. It was to
Okay.
the back of our property, garage area.
Was
And that was the work that was being done.
included in the original permit?
Well, she just.
Madam Chair, if I could ask a question. I assume I don't know the mechanics of what you come here with. Are all the board members provided with a book that has each case, the materials?
Mm-hmm.
Are those allegations?
No.
So are those allegations that were made, I mean, other than Mr. Stinson testifying to it, we don't know who these people are, what they said, what they've
Which is
alleged.
why we asked for a continuance.
No, you set this for a hearing today. Again, we are objecting to any continuance. We proved our case that we're in compliance.
But I think that law that was passed because,
They're not anonymous complaints.
I know, but, yeah.
But the board is being asked to make a judgment call on something. And did you all receive copies of those complaints so that you could look at them and see what they said?
No. That's what I'm
I mean,
saying,
that's the
yeah.
evidence.
That's what I'm saying, that the anonymous complaints was kicked out because too many people were abusing by filing anonymous complaints.
But are those complaints that were non-anonymous, are they included in the materials that you have?
No.
It's not even.
No, it's not included.
No.
So we don't have it. We don't have any proof. We can't sit here and say, well, we
can't make a decision, right?
Do that.
I mean, the burden of proof in these cases is very low. I believe there's an old Supreme Court case that is a substantial competent evidence, which is somewhere below what you would see in a civil
That's
trial.
not a problem.
But I'm going to leave that to Ms. Diaz because she's handling from the staff end as to what she feels.
I'm sorry, can you repeat the question?
I'm not asking a question. I'm basically here trying to figure out what the violation is.
Yeah,
Exactly.
so we're gonna, Mr. Stenson's gonna print, he's gonna email me the complaints and I can print them and I can enter them into evidence if the board will allow. Typically, we don't enter complaints into evidence because people are cooperative with us and let us go on property to prove that they're not in compliance. They haven't done that though. So they haven't proved compliance, but we will prove non-compliance.
Again, we
with the
have
complaints.
proved compliance.
So-
Just for that portion.
That was the only work that was done. That's the only thing
We just
that.
want to clarify, we
If-
object to any
again,
finding that they are in compliance. They
The
haven't
city,
proved that.
the
All
city
they
has
proved is
not,
that we haven't entered
the
into
city has
it.
not proved that there's
Let me
any
finish.
work that
Let
was
me finish. I
unpermitted.
didn't interrupt you.
Make that motion.
So if we can enter our complaints to show, well, our burden of proof, which is not a very high standard, as Mr. Riggio said, that will be enough. They have not presented anything to counter the facts in our complaints. Can you email that to me?
Leaning towards
Okay.
So would you rather postpone this case and move on, or
Yes.
wait for this?
Whatever the board, I would prefer to move on and then come back, or we can
I
wait.
think we
whatever.
need to continue it.
We can also
Again,
continue it.
I'm objecting to any continuance
Well, that's
at
all
this
right.
time because
We do have grounds to continue because
You
we
can
have-
object, but we can still do it.
I understand that, but again, what they're alleging is that there was unpermitted work. They have not proved what the unpermitted work was.
Okay, I'd like to make a motion that we continue this case in 15 minutes and move on to the next case. That
Second.
way we can get this over with and, yeah, get it resolved.
What was your motion again?
To just continue this case in like
15 minutes.
15 minutes.
Second.
Okay, it has been moved by Mrs. Roberts, second by Mr. Gonzalez, that we continue this case in 15 minutes. which would be 10:55. Mr. Gonzalez.
I think you'll probably need more than 15 minutes.
Yeah, I do too. I think it should be on
I was-
the end of the.
To the end of the meeting, to the end of the,
You're rescinding that to.
yeah, I'll make a new motion that we.
Well, can I offer a friendly amendment to that? I would think that we need to continue it to our next meeting so they can have time to bring whatever needs to be brought. I mean, that's not
That
gonna
is the
happen
city's
today.
request, but we respect the board's decision.
Yeah, that's not gonna happen today because it's information missing. There's, it's gonna be a back and forth.
Okay, I'll make a amendment.
Again, I like to put on the record that we're going to object to that. My client
Okay,
has paid
fine.
for
They were
legal
in the middle of a
assistance to.
motion. Rules of procedure is not to
Yeah.
interrupt the board when they're in the process.
So
Yeah, I just
already
want to put on
offered to
record
make-
before the motion,
Yeah.
if I may, that we're objecting to it.
Okay.
My client has already incurred legal expenses.
Mhm.
In order for her to come back to another hearing, she's going to incur more legal expenses. The city set this for today. They don't have substantial proof, and to give them a second bite at the apple when there's absolutely speculative in nature. The complaint, there's general allegations that there's some renovations that were being completed. At that time, my client came into compliance when she applied for the permit.
Okay, but.
Okay, well, we agree, but we have a.
Yeah, I have a friendly motion that I'm bringing to the floor, which is that we, in this case,
I thought she.
Yeah, we already had a motion.
she made a motion and I
Seconded.
offered a friendly motion.
I think I have to amend my motion now.
Right.
Well, that depends.
Yeah.
If you accept my motion, then I just finish my motion. If you don't accept it, then you go on with your motion.
Mr. Trujillo, what do you, am I supposed, can I do that? I don't know.
And she step back and let him make the motion.
I offered a friendly amendment.
No.
How many copies?
If you can make an amendment to a motion, but that amendment has to be voted on, and then the underlying
But
motion
do
is
I have to
voted.
make it?
Yeah,
Since
'cause
I
she
made the
the
original one. I
If you-
have to amend my motion, correct?
No.
Well, if
Yeah.
you could amend yours, or Mr. Gonzalez could amend your
Right.
motion. Once there's a motion out on the floor, then it's subject to amendment by, you could amend yours, Mr. Gonzalez could, any member of this board could. But each one has to be voted, an amendment has to be voted
Right.
on separately.
Exactly.
Okay. So
That's what I was
you're
So,
amending
and it's up to the
next
chair to
round.
control
Yeah.
who does what, when.
Yeah, because her motion was 15 minutes. We don't have that time to settle this.
Okay.
We
so
need
make
more
the
time,
motion to-
and the city's attorney also is indicating that they need more time.
Gonzalez make the
So,
motion.
so I made my friendly amendment.
Mr. Gonzalez, if I
Yes.
may, I think they're sort of separate motions, actually.
Okay.
It's not so much an amendment.
All right.
Ms. Roby's motion for 15 minutes, 15 minutes is probably close to going by. But if that doesn't pass, then you could then make an amendment to
That's
say,
what I was saying.
let's do it next, if that's what you desire, doing it to the next board.
Yeah,
meeting.
but-
Amended it herself.
But in the parliamentary procedure, if you offer a friendly amendment and the person accepts the friendly amendment, then
Well,
we just move on.
I think it comes down
That's
to,
fine.
I think that both of you are saying you made I believe, the same amendment, and it would come up to who made it first. Whether
Okay,
it was
well, he
Mrs.
has agreed that she can rescind it and make it for the next cutoff, and then we'll do it. Would you rescind and make it for the next cutoff, please?
Okay. I'll make an amendment to my original motion that we go for a continuance, and I motion that in case number CEB 05-26-93, Titus J. McCutter at 815 North Grandview Avenue, to be continued till the next cutoff, which is 6/3/26.
Okay. All in favor?
Aye.
No. No.
Okay. 2 noes and.
Not voting.
Give roll call.
Not voting.
Alice,
No.
Marsh,
Not voting.
Roby,
Yes.
Roundabout,
No.
Mr. Gonzalez,
Yes.
Ms. Hines,
Yes.
Ms. Callahan,
Yes.
it's like three and 2 noes and no vote. How'd that go?
Okay. She abstained, which I don't think she
Can
can do.
I-
but- Okay. All in favor for next,
She didn't vote at all.
all in favor for next cutoff?
Aye.
Aye.
There should be a
That's
motion.
four.
It's-
She made the motion.
Okay.
She
Yeah,
made
she
the
made the
motion.
motion.
We're doing
Yeah.
it.
So,
And you
yeah.
seconded it, right?
Yeah.
Okay.
So there's 4
4-3.
yes,
Okay.
and there's 3 no, 2
Secretary,
no's,
it was
and 1 out.
motion by Mrs. Roby, second by Mr. Gonzalez, 4-3. Yes, 4 for yes.
So, just a moment.
And 2 for no. And 1 no
I
vote.
missed somebody.
Okay. Yes, yes, yes.
That's 4.
And.
Ms. Roby.
No. And Ms. Roby
Right.
was 4. Ms. Roby, Mr. Gonzalez, myself, and Ms., yes.
Okay, yeah.
If you'll allow me leave, just as a courtesy to the respondent, I wanted to provide him a copy of the complaints today, if that's okay. So I'm just gonna step out. Thank you.
Okay, but you have the count. You
I'm
have
gonna
to-
bring a copy today for everyone. We still appreciate the continuance to give the respondent time to
Okay.
this over, but we do have our evidence today that we wanted to enter into evidence, if you will allow and to give the
Yes.
respondent.
Okay.
Have the vote for continuance is 4 yeses and 2 noes.
Yes.
So the motion carries.
We'll wait.
Does the motion carry? Okay.
To
Yeah.
continue, yes.
Okay, perfect. All right.
So the motion carries.
Yeah.
9 copies. 7. Would you like one too?
Yes, please.
Yes.
Do you want 2 copies or 1?
1 is fine.
1? Okay. I will be right back. My brother-
Okay.
Okay, and I haven't read this, do I have to on here?
Well, you would just redo continuance. It's here by order.
Yeah, I know what I'm saying. Okay. I hereby order the case number CEB 052693 against Titus J. McCarter for the property at 815 North Granville Avenue be continued until June 3rd, Okay.
Well, actually, it will be heard on June 7th.
11.
11th, okay.
That's
The
the-
cutoff is June 3rd. Okay. Okay, thank you, and we've decided to continue it and do it that way. Okay. Thank you. Okay.
Just for clarification, it seems like the city is alleging that because they have not been allowed to inspect the whole property, that she's not in compliance.
Okay. We, the board, are alleging that we don't have enough of the evidence on either side, so that's why we are continuing it, so everybody can come back with their proof. Okay?
The reason why I'm asking that is because you're gonna rule on whether she's in compliance or not.
Right.
And from my understanding, for her to come into compliance, she needed to apply for a permit.
Okay.
So is there gonna be some other, is there some other stipulation that has to occur for her to come into
No, you would have
compliance?
to get with,
You wanna wait for
the attorney
Ms.
there.
Diaz to come back in?
Oh,
She should be
she's
back in
not
a
here?
minute.
Oh,
She just went out
okay.
in the hallway.
Okay, she'll be back. Okay. And, oh, she went to get the copies. Case number. Okay. There. Okay, we're just holding up until she come back. Well, she just getting copies to give us. We can go on because the vote is final.
Question he has to be answered by her.
Yeah, but they can do that over there if
Okay.
you would. So we can continue, okay? Thank you.
Thank you, Board.
She's gonna come back in. Okay. Case number 19, CEV 052682. Eric M. and Kathy D. Ashley, 624 Park Drive. Ms. Kirk. Okay, sir, would you be sworn in?
Will you raise your hand? Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? And can you state your name and affiliation to this case?
Eric Ashley.
Thank you, sir.
Mr.
Okay. This is a complaint-generated case that I received for outside storage, debris, damaged fencing, missing part of the door frame, and missing address numbers. First notification was 12/27 of 25. Compliance was due 1/27 of 26. I visited the property yesterday. There's been some corrections, but the property is still in non-compliance. Staff's recommending a finding of non-compliance with compliance due by the next cutoff.
Ms. Ashley, would you like to say anything?
What do you need done? What else you need done?
I spoke with a gentleman on site yesterday, and I showed him. He said he would speak to you. So the address numbers have to be on the house. I gave him my card. He said he was going to give it to you to call me as well.
Okay.
Okay.
The numbers, they had the numbers put on the side of the house, and they are on the mailbox. What else do you want?
They need to be on the house.
Some who put them on the side of the.
Okay. I only saw a 6. There was a 6.
You seen the one on the front.
Okay.
The
Okay.
other two came off
In
on the
addition,
side, it was 624.
okay, just give me a call, and then that's why I gave my card yesterday, and then we can discuss it and then get it in compliance before the next hearing.
Okay.
And we're good to go.
Sir, I believe they have to be on the front, so if an emergency vehicle pulls up,
Yeah, we
they'll see
got-
it from the
we got
street.
them out on the mailbox on both
No.
sides of the mailbox.
Right, if you give me a call, I'll explain it to you. Yeah, you can give me a call.
No problem. No problem.
Okay, is there a motion?
A motion that the respondent, Eric and Kathleen Ashley, in case number CEBO 52682, for the property at 624 Park Drive, be found by non-compliance and order the respondents to come in compliance by the next cutoff of 6/3/26, or be returned to a hearing before the Code Board enforcement on 6/11/26 for a consideration of a fine up to $1,000 per day.
Second.
Okay, it's been moved by Mrs. Callis, second by Mr. Gonzalez. All in favor? Aye. The vote is unanimous. I hereby order the respondent, Eric M. Ashley, for the property at 624 Park Drive to be found in non-compliance, or order the respondent to come into compliance by June 3rd, next cutoff date or two be returned to a hearing before the Code Enforcement Board on June, where? June 11th, for consideration of a fine of up to $1,000 per day. So would you please stay in touch with Ms. Kirk and you all can get the things. Thank you.
I'll be done in about 2 minutes.
Case number 20 CEB 052683, Alvin Michael Patton at 416 Marion Street is cited for failure to correct violations of the land code. Ms. Kirk, sir, would you be sworn in, please?
Do you swear or affirm that the testimony you're providing will be the truth, the whole truth, and nothing but the truth?
I do.
And can you state your name and affiliation to this case?
Alvin Michael Patton, homeowner, 416 Marion Street.
Thank you.
Okay. Ms. Curry.
Okay. This is a complaint-generated case I received from the police department for exterior conditions. Upon my inspection, I observed unmaintained landscaping, outside storage, unpermitted accessory structures, boarded windows, missing address numbers, and debris. First notification was January 7th of 26. Compliance was due February 7th of 26. I visited the property. It's still in non-compliance as of yesterday. Staff is recommending a finding of non-compliance with compliance due by the next cutoff.
Mr. Patton, would you like to say anything?
I'm not quite, well, I pretty much, shaped up everything. The address is able to be seen in front of the,
I'm sorry, we're in the middle of a case.
I had a couple break-ins, in the past, and is the reason why, I allowed certain things to be,
Okay.
to grow.
But
And nothing was done about the break-ins. And,
Okay.
I have spoken with Mr. Patton on site recently, and I understand his concern, and he has made some improvements. One thing we did discuss, which he didn't do, and I failed to mention, is there is an egress concern. There's the front door is blocked, and I let Mr. Patton know that for fire safety, just egress. It needs to be an unobstructed path into the front door. So if I could change my recommendation to have the egress within 48 hours cleared, the front door, and then the rest by the next cutoff.
Okay. Is there a motion to that?
I'll make them.
Go ahead. Go ahead.
It's in non-compliance.
All right, I'll make the motion. I motion that the respondent, Alvin Michael Patton, in case number CEB 052683 for the property at 416 Marion Street, be found in non-compliance, in order that the egress to the front door be remedied within 48 hours. The rest to be found in non-compliance in order to respondent to come into compliance by the next cutoff, which is June 3rd, 2026, or be returned to a hearing before the Code Enforcement Board on 6/11/2026 for consideration of a fine up to $1,000 per day.
Okay, Ms. Marsh, can you rescind or add on? She wanted the egress, the front door cleared.
I did put that in there.
Oh, you did? Okay, my fault.
Second.
Okay, it's been motioned by Ms. Marsh, second by Mr. Gonzalez. All in favor? Aye. Okay, it's unanimous, Mr. Secretary. Thank you.
thank you.
Case number CEB 052692.
Are we gonna return back to that?
Amadale R. Stevens at
Excuse me.
1129 Madison Avenue
Madam Chair.
is in,
It appears that there's a problem with the last motion.
Yes, unfortunately, the egress was not part of the original violation,
okay.
so we really can't include that since we did not notify them on the notice of violation.
Oh, okay. Okay.
I would
Mr.
like to
Patton.
amend my motion.
Mr. Patton.
Mr. Patton,
Mr. Patton. He doesn't even hear me. Mr. Patton. Mr.
this way.
Back over here.
So she would rescind that and do it again? Yeah,
Probably would be
appreciate it.
best to do it that way. Mr. Patton, apparently the egress was included as part of the motion, and you were not originally cited regarding the egress. You would be recited, so it might be good in your best interest to try to work with the inspector to work it out quickly. But the motion should only pertain to the items that you have been actually cited for.
Okay.
That's a, so do you,
Shall
I think it would probably be best for the motion to be withdrawn and restated so that only reflects what he has actually been cited for
Non-compliant.
in
Okay.
non-compliance.
I withdraw my motion,
Okay. Agree.
and then just go again?
Yeah.
Okay. I motion that the respondent, Alvin Michael Patton, in case number CEB 052683, for the property at 416 Marion Street, be found in noncompliance and order the respondent to come into compliance by June 3rd, 2026, or be returned to a hearing before the Code Enforcement Board on June 11th, 2026, for consideration of a fine up to $1,000 per day.
You can go.
Do I need to know what changed?
Okay, yeah, no, we just left out the egress because it was not in this.
Oh, okay.
thing.
It's outside
So,
storage and
yeah.
debris was in there, and that's
Okay.
obstructing the egress, though. so.
And you may want to work with Mr. Patton to get it resolved if he can do it
I
quickly,
tried.
so he doesn't have to come back.
I
here
have
again.
tried. I have tried, but okay. We'll just leave
Okay.
it there. Thank you.
Okay.
I second that motion.
Okay, it's been motion by Ms. March, second by Mr. Gonzalez. All in favor? Aye. Okay. It's unanimous. Okay.
Do we want to go back to?
Wait, no. Do we do with him?
Because it
Okay.
doesn't look like we have any
I
more
move-
respondents.
Okay. I hereby order that case number CEB 052683 be amended to allow the respondent named Mr. Michael Patterson to bring the property into compliance or to be returned.
No, it'd be a non-compliance. These are compliance, non-compliance cases.
Right, okay, up here, okay. In order respondent to come into compliance by, June 3rd, next cutoff date, or to be returned to a hearing before the Code Enforcement Board on June the 11th for consideration of a fine of up to $1,000 per day, okay? Case number 21 CEB 052692, Amanel R. Stevens at 1129 Madison Avenue. Mr. Clifford?
It's in compliance.
Is compliance. As of 5/11/26, okay. Case number 22, CEB 052687, Melissa Cheney at 316 Fletcher Avenue.
Excuse me, Madam Chair, I'm sorry.
Just look through people.
Are you gonna bring them back up for
For what?
clarification?
No,
Oh,
for
I'm
what?
sorry.
I mean,
Yeah, an order was
we
done.
did.
I was just giving him the.
Okay.
Yeah, you was just supposed to
But-
give him that information.
I know, I do believe he might have been waiting because I said I was going to enter this into evidence, and I think he might have wanted to object, I assume.
Well, we've closed that.
He asked the
We've
he asked the
closed-
question.
I'll bring this at the next hearing then.
Okay.
But he asked a question that only you can answer.
Oh, you
Yeah,
have the
well, he
question.
can do that
Okay,
with
I'm
her.
sorry,
They
yes.
can do that out there. You know.
Okay, so I'm confused as to what's going on and what we need to do next.
Come to the next hearing.
Okay.
Yeah, so
Yeah.
I'll email you, sorry.
He's trying to.
my
get
question to the
this
board,
done.
because they continued it and they said we needed to come into compliance by June 3rd is what I understood the motion to be.
Oh, that would be
And-
wrong.
No, yeah, that wasn't it.
Yeah.
And we're gonna, when
It
you
was that
come
we were
back,
gonna continue your case.
right, we're gonna review everything.
She
You
entered, she
bring all
said,
your evidence,
And
he has his
on
evidence,
the record, she
then we
said
make
that
a
we needed to
decision.
come into compliance by June 3rd and that the meeting was gonna be on June 11th.
Oh.
So my question posed was, what is the requirements for compliance? Because on the notice,
That would
the
be
the
with,
compliance,
So-
the notice of
Miss-
violation says in order to come into compliance, she was to apply for a permit.
Yeah, you are not found and not compliant, so there's nothing for you to do on
which case was that? Case
other than come
number?
to the next hearing
Which
and
case
prove
was
why
that?
you're in compliance. You were not found and not compliant, no
Case
order
number.
negative was issued against you. The only thing that was done was continuing this hearing for the next hearing to make a determination at that date.
18.
I wasn't here for the
Okay.
motion, but that's what I
Yeah,
was requesting.
Case number 18, okay, yeah.
I know I gave you
Brenda,
my
what do
card.
you have as the
Okay.
motion?
If you have a card I can have, so I can email this to you.
We
by the end
have
of
the
day.
motion has been passed and everything. We finished with that, now she's telling him.
I think Mr. Huggins is stating that what he heard was that there was a motion that related to non-compliance, and
I don't know what the
No,
board
we
ordered.
made
I
a
asked
motion
for-
to continue.
it's just continuance.
Yeah, what I asked
Yeah,
for was
just
to
continue.
continue,
Okay.
so if
Okay.
that was what the board.
And I'd also request that typically I see an agenda item and I see the pictures. And if there's other materials, I need to see copies on this one as well, so that I know what it is that Mr. Huggins is seeing, and so I can advise the board as to where I think things are.
So typically, we present pictures in slideshows. Do you guys now want us to start presenting
No,
printed
this,
pictures for all of them?
this one seems to be based, if I understand, that someone has alleged that something has happened. And this is going forward on the strength of those allegations,
Yeah.
not on pictures of anything.
Right.
And so I need to also see what those allegations are, and, you know, whether they're anonymous, if they're, who they are. And I'm sure Mr. Huggins, was he copied on those?
I just printed them and gave him a
Okay, so
copy.
he has
That's
those.
from another case.
So I was going to prepare, I guess I could file, with the board secretary before the hearing and CC the respondent, so he has a copy of the evidence in advance that we plan to present at the next hearing.
Okay, thank you.
Is a week before the hearing enough time to present that to the board?
No.
How much time would you like for the
When?
city to file? How much time before the next hearing would the board like?
A couple of weeks,
Let me
because
ask
we've
this,
completed this.
because I
He
just
has to,
realized
both
that-
sides have to
The
bring
date that you
in,
chose,
excuse me, please. Both sides have to bring in the evidence for us to hear. That's what we
So a
want.
couple weeks, okay.
Okay?
In this
And
case, we should hear it and see it.
You're right.
Okay.
So
I
that's.
think you have a conflict date-wise.
I do.
Yeah.
Date
I don't have
wise.
an
Okay,
objection
the
to a
next
later
case,
date
but-
if that works better for you.
Yes, if we can do the August.
I
date,
think
that
we're
would be
on
better.
22.
Okay,
I mean, yes.
Well, I don't want to speak
Okay.
to the inspector. I have no objections. Mr. Stetson, do you object?
yeah, could you all get with him, Mr. Stetson, so we can
Any
continue?
objections to
No.
moving this
No, I do not.
August? Okay.
Okay.
I motion for the board to rehear the order for continuance and amend it to August for judicial expediency for both the respondent and ours. He's saying that he can't come in June.
Oh, okay.
And so to be fair to him, I wanted to give him the opportunity to come at a
Okay.
date that would work for him. And we will have, since it is August, we'll have plenty of time to submit this long before that hearing.
So we got.
So, Ms. Roby, you wanna
I think
restate
we have
that?
to rescind
Ms.
that,
Roby.
and you have to go back to that
You wanna
case,
do that?
and then
Okay.
redo another motion.
Okay.
Just
Can we
reset it
Change the
for
date.
August.
rescind that one, redo another motion for August,
I'd like to rescind my original motion, and the new motion is I motion that case number CEB 05-26-93 against Titus J. McCotter at 815 North Grandview Avenue for the property at 815 North Grandview Avenue to be continued, cutoff date 8/5/26 with the meeting on 8/13/26.
okay. Are you second?
Second.
Okay. It has been moved and properly second. All in favor?
Aye.
Aye. Madam Secretary is unanimous. Okay.
Thank you,
For
Board.
August the 2nd, okay. Okay, thank you. Okay, case number 22, CEB 052687, Melissa Cheney at 316 Fletcher Avenue and 314 Fletcher. Mrs. Domingo.
Good morning. I'm Inspector LaWanda Domingo. My credentials are on file with the city. This case opened March 31st of 2025, and the owner was notified June 6th of 2025 for violations of outside storage, trash, rubbish, and debris, vehicles and trailer parked on grass, expired roof permit with no final inspection, unregistered inoperable vehicles, and a roof with a tarp. I did have contact with the owner back in September of 2025. They did get their permit reinstated, and it has since expired again for the roof permit, March 21st of 2026. So I'm requesting compliance by next cutoff for this property.
Nothing's been done?
They've done some cleanup to some of the storage items, and there has been some repair to the roof. However, the permit is expired again with no final inspections, so.
Okay.
I'll make a motion. I motion the the case number. I motion the respondent, Melissa Cheney, in case number CEB 05-26-87 for the property at 316 Fletcher Avenue and 314 Fletcher Avenue, found in noncompliance, in order the respondent to come into compliance by cutoff date of 6/3/26, or be returned to a hearing before the Code Enforcement Board on 6/11/26 for consideration of a fine up to $1,000 a day.
Second.
Okay, it's been motioned by Mrs. Roby, second by Ms. Marsh. Okay. All in favor? Aye. Okay. Thank you,
Thank
Mr.
you.
Mango. Okay, okay, so you're saying I shouldn't hear my order here, it should be this.
Well, you can say hereby order, that's fine.
I'm saying I was reading from that. The City of Daytona Beach Code Enforcement Board hereby finds the respondent, Melissa Cheney, in the case for CEB 052687 for the property at 316 Fletcher Avenue to be in noncompliance, and order the respondent to come into compliance by June 3rd, to be in by June 3rd, typically next cutoff date, or be returned to the hearing before the City of Daytona Beach Code Enforcement Board on June 13th. Typically, the next hearing date for consideration of a fine of up to $1,000 per day. It was motioned by Mrs. Roby, second by Mrs. March. And it was all in favor, 7-1. Okay, case number 23, CEB 052689, Thomas H. and Julia A. Allen at 28 Lion Paul Grand. Mr. Roosevelt.
Okay, as it pertains to 28 Lion Paw Grand, this was a citizen complaint case. A site inspection was conducted, and it was determined the property had the following violations: work without a permit, brick pavers. The property was notified January the 31st, 2026. The property was to be in compliance February the 30th, 2026. My last date of reinspection was May 14th. May 14, 2026. The result of my reinspection was non-compliant. I've had contact with the property owner. Staff requests non-compliance, compliance by next cutoff.
Okay. Is there a motion?
I'll make a motion.
I have a question. So you say you did have communication?
Absolutely.
And?
They haven't applied for the permit.
They haven't?
They have not. Yes, ma'am.
Is this a community HOA department?
Lions
area?
Paw out by LPGA.
Okay.
So I'm quite sure it's HOA.
Okay.
Yes, ma'am.
They don't monitor, they
Ma'am?
don't monitor their work.
I'm sorry, say that again?
They don't monitor what goes on in their development as far as HOA, or is that who the complainant was?
Oh, you say they don't monitor? Oh, they do monitor.
Okay, okay.
They do monitor.
Ms. Marsh is trying to get on the floor, you know.
I make a motion, the respondent, Thomas H. and Julie A. Ellen, in case number CEB 052689, for the property at 28 Lions Paw Grand, be found in noncompliance and order the respondent to come into compliance by June 3rd, 2026, or be returned to a hearing before the Code Enforcement Board on June 11th, 2026, for consideration of a fine up to $1,000 per day.
Second.
It's been motioned by Mrs. Marsh, second by Mr. Gonzalez. All in favor?
Aye.
Aye. The City of Daytona Beach Code Enforcement Board hereby finds the respondent, Thomas and Helen Elon, in the case number CEB 052689 for the property at 28 Lion Paw Grand to be in non-compliance and order the respondent to come into compliance by June 3rd. Typically, the next cutoff or be returned to the hearing before the City of Daytona Beach Code Enforcement Board on June 13th. Next hearing date for consideration of a fine of up to $1,000. Again, it was motioned by Ms. March, second by Ms. Roby.
June 11th.
No, it's
June
second by
11th?
me. I second it.
Okay, second by Mr. Gonzalez. Okay. Thank you, Mr. Butler. Okay.
Oh, you got it.
No, I'm
All right.
okay, yeah.
All right.
Just use you there.
Okay. You okay?
Yeah, I'm okay.
All right. Okay, so the next case, I think we're at case 24, CB 052690. Is that the one we're doing?
Yes.
Yes.
Okay. All right, so this case concerns Lakshmi Maya Nita and Vishkolik Nita. Best I could do. At 268 Birkdale Drive. And Mr. Butler.
Okay, as it pertains to 268 Birkdale Drive, this is a citizen complaint case. I conducted a site inspection on February 10th, 2026, where it was determined the property had the following violations: unmaintained landscaping, hedges. A first notice was received on February 28th, 2026. On March the 9th, 2026, the violations was to be into compliance. Last day of my reinspection was May 13th, 2026. The result of my reinspection was non-compliant. I've had contact with the property owner. Staff requests non-compliant, compliance by next cutoff.
Any questions from the board?
I don't understand where the hedges.
Okay, the hedges used to be about 8 foot tall, so they've already begun to cut them, and what's left is far in the back. But of course, it's the rainy season. Is if they wait any longer, they'll be back up again. But they're working on it.
So the city has a requirement on how high hedges can go?
Yes, I talked to my boss, and I think it's
Yes, it's
can't
part
be
of the
8
land
foot.
development code.
Yep. So they're about 8 foot, which they're out of compliance. So as you can see, they cut them all the way down to about maybe 3-4 feet tall.
Yeah, in the front yard, it is only allowed to be 4 foot, and in the backyard, it's only allowed to be 8 foot.
That's good news.
Yeah, we learn something new every day.
That's right, there you go. Okay, so do we have a motion on this case?
I guess I'll make a motion. I motion that the respondent Lakimi Mayanita and Vishanka Nita at 268 Barksdale Drive to be found in non-compliance in order to respond to come into compliance by cutoff date of 6/3 or be returned to a hearing before the Code Enforcement Board on 6/11/26 for consideration of a fine up to $1,000 a day.
Second.
Okay, motion has been made by Ms. Roby, second by Ms. Marsh. Let's see, which one are we using here? Okay. So the board finds the respondent name Lakshmi Maya Nita and Vishunkalik Nitya in the case number 052690 for the property at 268 Birkdale Drive to be found in non-compliance, and the board orders the respondent to come into compliance by the cutoff date of 6/3/26, or to be returned to a hearing before a code enforcement board on, what's that, 6/11?
6/11.
6/11.
Or no, 6/13. 6/11.
6/11. For consideration of a fine up to $1,000 per day. All those in favor? Do we vote? We can vote on it.
You need to vote.
Yeah. All those in favor?
Aye.
Okay, opposed? Okay, motion carries. All right, next case, Ms.
Mrs. Himes, did you vote on that?
No, because I wasn't in.
Okay, so you're now returning.
Yes, I'm now returning, thank you. Okay.
Okay,
Okay.
case 25.
Case number 25, CEB 052691, Thomas Rodriguez at 121 Baywood Drive.
As pertains to 121 Baywood Drive, this is a field generated case. I conducted a site inspection on February 10, 2026, where it was determined the property had the following violations: damaged fascia and peel and paint. First notice was received on February 18, 2026. March 28, 2026, the violations was to be in compliance. My last date of reinspection was May 13, 2026. The result of my reinspection was non-compliant. I've had no contact with the property owner. Staff requests non-compliant compliance by next cutoff.
If this was about peeling paint, what about the boat sitting in the?
The boat is gone. I'm sorry.
It's gone.
Okay.
Okay.
Yeah.
And the car that, well, in the other picture, there was a car parked in the grass, so I'm assuming that's gone too.
Well, that was there just yesterday. So if they don't take care of the violations within a couple of weeks or so, then this is what happened. So this is over a couple of months period of time. So now we have that. Hopefully I can talk to someone and I'll get it resolved.
Is there a motion?
I'll make a motion. I motion that the respondent, Thomas Rodriguez, in case number CEB 052691, for the property at 121 Baywood Drive, be found in non-compliant and order the respondent to come into compliance by June the 3rd, or to be returned to a hearing before the Code Enforcement Board on June the 11th for consideration of a fine up to $1,000 a day.
Second.
Okay, all in favor?
Aye.
Okay. The City of Daytona Beach Code Enforcement Board hereby fines the respondent, Thomas Rodriguez, in case number CEB 052691 for the property at 121 Baywood Drive to be in non-compliance and order the respondent to come into compliance by June 3rd. Typically next cutoff day, or to return to the hearing before the City of Daytona Beach Code Enforcement Board on June 11th to typically the next hearing date for consideration of a fine of up to $1,000 per day. Okay. Thank you. Let's do our next case. Case number 26, CEB 042674. Buck. Okay. Archibald, okay, at 124 Prestwick Grand Drive.
Yes, ma'am. As it pertains to 124 Prestwick Grande, this is a field generated case. I conducted a site inspection on February 10th, 2026, where it was determined the property had the following violations: work without a permit, brick pavers. A first notice was received on February 26, 2026. On March 6, 2026, the violations was to be in compliance. The last date of my reinspection was April 30th, 2026. Result of my reinspection was non-compliance. I've had contact with the property owner. Staff requests compliance by next cutoff. And just to let the board know, he has applied for a permit. The HOA has to write him a letter, then present it to the city, and then they will move forward with whether to issue the permit or not. So that's where we are with that case.
Okay. I'll make a motion that the respondent, Sarah Rocha, in case number CEB 0426-74 for the property at 124 Prestwick Grand Drive, be found in non-compliance and order the respondent to come into compliance by June the 3rd, or be returned to a hearing before the Code Enforcement Board on June the 11th for consideration of a fine up to $1,000 a day.
Second.
It's been moved by Mrs. Rodenbach, second by Mr. Gonzalez. All in favor?
Aye.
Okay. It's unanimous. Okay. Before we adjourn, I'd like to thank the board because they gave us a new sheet and included myself. It was a little navigating there to be done. But thank you so much. And Mr. Gonzalez, you don't have the right. You should have this version. And I have two questions from the attorney and from staff. What is the date we should use? One time they tell us that we should use the cutoff date. Then again, we should use the attendance date. So which date do we use?
For compliance on the order,
Yeah,
it would be the cutoff date.
the what
The
now?
cutoff date.
Okay.
Madam Chair,
No.
Madam Chair,
Okay. Yeah.
we will be revising that. There is a couple areas in your sheets that don't follow the way it's supposed to be.
Okay.
So next month you will have that. She'll send it out early.
Okay, the other thing on my
If I,
sheet,
if I could say something, Madam Chair. There are actually there's a reason why the statement is made regarding the next meeting. And that is sometimes respondents play games and make believe they never got the notice. If they get the notice here and they're told they're going to appear at a hearing, if they don't get the notice, it's too bad. They were told. And so the notice requirement is met, and you can avoid the gamesmanship that sometimes people play. But there are two dates. The first one is the date they have to come into compliance when the inspector signs off and either brings them forward to a hearing. Then there is the actual meeting date, which you can provide. And that's why I have sort of done that in the past, to try to use the two dates so that they know first they got to come into compliance by this date. And if they don't, then they've been put on notice that they have to appear back here on the following date when you meet.
okay, the other thing I have on my sheet now, I can do the two dates, but then at the bottom, when I said motion by Rodenbach, second by Marsh, then it says the vote should be carried then, after my statement. Now, which is it?
Again, we need to revise that
Oh,
as
okay.
to how it is.
Okay.
It's got a little bit out of order.
Okay, okay. No, but just, you got enough, I was just saying, I want to learn it right, okay. And the board was, you all were terrific, I was horrible.
I got a couple questions. On this case 18 for this McCotter, are we gonna get the paperwork, what the original complaint was, that we're gonna see work without a permit?
She considered an ex parte communications because he's not here. Would I be
Yeah,
able to
I
answer
think
this?
I think that, I would say I think the board should receive a full case.
Right.
Like
You
Oh,
everything?
you're asking a procedural question. I can answer
Yeah.
that. Yeah, in terms of how do you want evidence presented to you? How
Did
would
you
like
print off something for us, though?
I did, but I didn't enter it into evidence because we weren't on the case, and I can't do
okay.
it now. But what I can do is, like what I said to him, a couple weeks before our hearing, I'll send it to your secretary, and I'll include Mr. Huggins and the respondent. That way, she can pass it on to you guys. I can't send it to you directly, and then he'll have a copy.
So it'll be like a lien review packet?
I don't put those together, but what it will be all of our evidence, the complaint, and I plan to put together a legal motion as a cover page for you guys to explain it. So
Yeah.
as of right now, that's what I
That
can.
would help.
Yeah.
Okay.
If you do
The
it
second
like
thing
that.
I got is this last one of these cases with the hedges. I think half of Daytona Beach is in violation with the hedges.
Yeah, but that was a complaint-driven case.
Okay, but
We
if,
typically don't, the inspectors don't go out just trying to measure hedges as a rule. But when we get a complaint about it, we have to address it, just like the height of a fence in the backyard or the height of a fence in the front yard. There are height restrictions in the codes that say what height they can be.
okay, I have a question about my own property. Because I have hedges between my property and my neighbors, and they're well over 4 to 6 feet. And my side fence is 6 feet, and my front fence is 4 feet. But my hedges are well above that. So if my neighbor complains that they don't like my hedges, I have to cut them down?
Would have to be whatever the code states,
Yeah, the height.
if we get a complaint in regards to that.
So can you give me the code that, for those hedge height or?
Yes, I can look that up and email it to you.
Okay,
You
okay,
can email it to the secretary who can email it to her.
okay.
I have a question. There are so many of these brick pavers without a permit. Seems kind of ridiculous. And then when you say this is a complaint-driven case, how does a neighbor, whoever complains, know that they didn't have a permit to get, do they actually go and
You
look
can
it
go on
up?
permit
Yeah,
site.
no,
Public
they just
record.
call
This
it.
is IMS.
Yeah.
I'm
On
sorry.
IMS, you can look it up at the public record.
So somebody actually takes the time to go and look, see if their neighbor got a
Yeah.
permit for the pavers and then complain to the city about
Yes,
it?
that is, especially
They
what's
don't
happened
like
out
you,
there
they'll do that.
in Mr. Butler's area. He has received numerous complaints in regards to the different homes out there. Some of them were built incorrectly per the original building plans that were approved, and some of them they have done, extensions to the sides. The reason that ends up being a case is sometimes they're changing the elevations between properties. But any of that type of stuff does require a permit, and when we have received a complaint, we look into it.
Isn't the contractor required to post a permit?
Yes, they're supposed to be posting the permit in a obvious place that you can see from the street.
That's another one of my questions for case number 18 is, are we gonna get how many permits have been pulled on that property? Because,
I think any discussion regarding
That
case
one?
18 should,
okay,
Oh, that's the one.
yeah.
We will
We
present all
won't
our
be
edits via
discuss-
email, and if you guys have questions or want us to present different evidence or additional, you can let the secretary or your attorney know, and we can provide that.
okay.
Can we ask the attorney to also provide us with copies?
You can ask anyone to prevent any, that's your right. I do want to mention though, as a clarification, the powers of 162 point, the one that I mentioned for the powers that the board has, I did misspeak. After, I just realized those powers only attach once an order of non-compliance has been issued. Once you have that order, you guys can order anything that would go towards compliance. Regarding the hearing for a non-compliance hearing, you guys can request anything, and while it's not the same force of law powers because an order of non-compliance hasn't been done, it would behoove both sides to comply with what you're asking for, since we're asking for something from you, if that makes sense. It wouldn't be an order, it would just be a request until an order of non-compliance has been issued.
I had a question on that same property. It said that it was zoned for single family, and yet there's three.
I'm not sure.
How's that work, Mr. Jones?
That will be.
Hypothetically speaking.
Yeah.
We
would
really
look into
shouldn't be
that
talking
if it was
about
just
that.
listed as a single
The
family,
attorney,
and they make it into a multi-family, that would be something that the city and the rental department would look into.
That's the zoning issue, isn't it, too?
I think the issues that relate to those types of things are best left for that hearing. And
Yeah.
you can
Yeah.
ask them at that point.
We
okay,
can ask
but we
hypothetical
can't,
questions about non-cases, but not specific cases, yeah.
Yeah, I
I
mean,
agree.
it's a
But-
hypothetical, but.
Yeah.
but how is the board to find out if they don't understand, if we gotta wait till the case come back to discuss it? How is that gonna work?
I'm sorry?
Okay, what he's saying, we
Yeah.
shouldn't be discussing that case at all because the case has gone through.
Yeah.
But I'm saying a lot of the questions they have, when can they answer them? They can't answer them during the,
They could ask
This is
during
a-
the hearing.
A hearing is a burden of proof
yeah.
situation.
Yeah.
The city provides a certain level of proof. The other side can rebut it. And the questions, the city has to anticipate what types of things you might want to be asking about. You don't get to ask in advance. Otherwise, you have a lot of things that are
Yeah.
outside the record and everything should be on the record. So the respondent in these cases has an opportunity to say, that they complied with the requirements and they required for procedural requirements, which is the burden lies with the city. It may be in code cases a much lower burden, but there's still a burden out there. I mean, there is a Supreme Court case from back in 1920s that said it was way below the standard of proof, which is,
The clear and convincing is the.
No, it's clear and convincing is for
It's the high-
criminal, the preponderance of the evidence, and it's way below that. But there is still some bottom limit beyond which I think any court would say, no, the city has failed to provide a case. And the burden lies with the city to provide that. And you can't sort of anticipate what you think they might need to provide because you're sitting as judges and you get to hear that when the case is heard. So does the respondent.
Yeah.
And if the respondent thinks something is objectionable, they can respond appropriately.
And preponderance of the evidence, the way we were taught in law school, it's basically more likely than not. So 51%
Right.
likely that we met our burden.
I think the Supreme Court case that has been rumored, I think Judge Wolf had mentioned something in his about this. It was somewhere around 30%.
I can look for the case.
And that is the type of thing. But, you know, things change. That's a case from, I think, 1929. So, you know, I don't know of any cases since that who've really focused on that. Laws change, judges change, world changes. So you just have to have a hearing where everybody does their best to try to convince you as a body that's hearing it, whether or not you ultimately go away thinking that that the one side has provided the appropriate amount of evidence and support to make their case. Mm-hmm. And they can also argue about the standard of the level of standard of proof. That's also an issue. And you see that sometimes in like criminal cases where, you know, what constitutes a clear and convincing? Is it 75%? Is it 67%? You know, and can you really make these things in percentiles?
I have another question. Is hypothetically, if you have a case and they prove that they had a permit was authorized and cleared, then is there somewhere that it encompasses what that permit consisted of?
Yeah, the permit, you could probably explain better. The permit should have details of what that permit allows and the scope of the permit. You can't go outside of the scope.
So we could bring that in?
Yeah.
On a hypothetical.
On a hypothetical base, yes, we can bring in what exactly the permit was for. It usually is typically detailed, even has, when you go into the permit in IMS, it'll show the plans, what was supposed to be done and what was done. So on any permit, when that comes up, we can always go in there and see what the permit was for on any case.
Okay, good idea.
Okay.
We need a motion to adjourn.
I'll make a motion to adjourn.
After the gavel hits, I have something I want to read, so.
I'll make a motion to adjourn.
Is this something that pertains to the board?
No. No.
Well,
No.
not really, no.
Okay.